Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great docket for you today, so let's get to it. First, is competency being raised again for Lori Vallow? The Alec Murdaugh homicide case is already turning into a dogfight. The OnlyFans model charged with homicide will have to sit in jail a little longer. A case is finally making it to trial, the Rhoden family murders. Wait until you hear what this 85-year-old sex offender wanted to do. No one will ever know. That's what he thought. And then finally, our dumb criminal of the day. Let's talk about it. Good day, aficionados. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that little bell so you get notifications of when we go live or put up new content, like we will tomorrow night at 6 p.m. Mountain Time. And then always remember and never forget that you can always listen to us on any of your favorite podcasting apps. Let's get to the docket today for August 29th, 2022. Open the record, please. First, let's talk Lori Vallow. Now, last week was a little crazy for me, okay? I had to appear on a case that's taken up a lot of my time. It's received some national attention, and I had to focus my efforts on that. So we didn't spend much time on some recent orders in the Lori Vallow case, and I want to go back over some of those orders and try to, make a prediction or read the tea leaves just a little bit. Now, first, the court set a hearing for August 31st, 2022 at 9 a.m., so just a couple of days away. What is that hearing, you may ask? Well, we don't exactly know, but apparently it's based on an order from August 24th of 2022. Apparently the parties requested some sort of ad hoc hearing, which kind of just fancy word for as needed hearing, and the status conference, and following a hearing on August 16th of 2022 regarding an on-the-record conversation with all parties being present, including the defendant. And apparently there was a discussion regarding the defendant's, Lori Vallow's, mental health pursuant to Idaho Code Section 18-210. Now, the court said that based upon the previous order entered on September 14th of 2021, and after due consideration of the factors set forth in accordance with Idaho Court Administrative Rule 32, finds that the discussion or the dissemination of the information is already sealed, the court finds that there was a compelling interest at stake to preserve a fair trial, and that no reasonable alternative exists to protecting the fundamental rights except to hear the hearing closed. Okay, a couple of things in there. So first, the statute that the court references in his sua sponte order regarding the sealing of the conversation references Section 18-210. Well, what is Section 18-210? That is the Idaho statute that specifically references competency. And it provides, and I will read it to you verbatim, no person who, as a result of mental disease or defect, lacks capacity to understand the proceedings against him or to assist in his own defense shall be tried, convicted, sentenced, or punished for the commission of an offense so long as such incapacity endures. Now, why do I bring that up? Well, first, the court would not inquire about Lori Vallow's mental health on their own, all right? And obviously, we weren't there, and the record is sealed, but based upon my experience, that is something that the defense raises with the court. So it would not surprise me. The reason for the hearing is for the defense to either supplement via a motion or a brief, or to allow the defense time to file this motion. Obviously, the issue was raised almost 2 weeks ago, but yet here we are setting it for a status conference. My guess is there's going to be something filed under seal that's going to explain why the defense counsel has concerns about Miss Lori Vallow's mental capacity. Now remember, Mr. Archibald previously stated in motions filed with the court when there was all the big discussion about speedy trial issues, and they claimed Lori Vallow's mental health was quite fragile. I think they also referred to as kind of a day-to-day type of thing. But it was very clear that he was setting the groundwork, and I mentioned then, setting the groundwork for I may have to raise this issue again. I think we're going to have to wait until the 31st to find out if Lori Vallow is going back to the state hospital. I hope I'm wrong, but I am leaning towards yes, she's going there. Next, the sealings of these records and motions being filed under seal are very, very unusual in criminal cases. Now, as mentioned previously, the court is making his own motion to seal on the record proceedings, and the court cites to privacy and whatever is there could prevent a fair trial to either party. I don't like the government telling us that we are too stupid to know what's going on in these legal proceedings. You just can't handle the information, you mere uneducated people. You don't know all the facts, and if you do, it'd be too complex for you to understand. That's really what the court is saying. Now, I get it. You redact social security numbers, you redact medical documents, things of that nature, but everything else is fair game. What more privacy interests could you have other than maybe redacting your social security number, your banking information, your medical records? I get that. But we're talking about people that are accused of killing 3 people, 2 juveniles and an adult. And somehow we're worried that this could result in an unfair trial? To whom? The defense? The allegations in and of themselves are prejudicial. And so I'm not exactly sure what the judge keeps thinking when he seals these records. Now, there's been allegations that have been raised by Chad Daybell's attorney challenging the grand jury proceedings, a motion to disqualify the prosecutors. That is something that the people of Idaho and the country, if not the world, have a right to know. Not just because it's a high-profile case. Hell, it should be made available in any case. And I can guarantee you, you could go down to cases where we have filed motions to disqualify a prosecutor, to motions to recuse a judge. They are a matter of public record. Sometimes they're embarrassing. Sometimes they even incorporate statements that people have made that look like they could be embarrassing. Guess what? It's public record. All right? So please, Judge Boyce, stop the sealing. Things done in secrecy and without explanation, or documents being provided, well, it makes people believe that shenanigans are going on behind the scenes. And that is how basically crazy theories are developed and perpetrated, right? So let the people know. Unseal the motions and unseal the hearing transcripts. I assure you, Judge Boyce, we can handle the truth, regardless of what is said in the court of public opinion. Everybody knows, and I'm sure Judge Boyce will make sure that a defendant can and only will be convicted by legal and competent evidence, and that's if, obviously, the prosecution can prove their case beyond a reasonable doubt. As Sophocles once said, "Do nothing secretly, for time sees and hears all things and discloses all." We'll get it eventually, all right? So let's just do it now. Next on the docket, this Alex Murdaugh case is going to be a dogfight, and I love it, all right? So we've been following the Alex Murdaugh case when his son Paul was charged with basically driving while drunk in a boat that resulted in the death of a young woman by the name of Mallory Beach. And I followed the case, and yes, it was interesting to me because it was a low country case. And I mean the low country in South Carolina because I have lived there in the past. I still have a residence there, and it just intrigued me. Some people like, oh, I don't get it, it's boring. But I thought there was something bigger there. It was just an example of power and corruption, how absolute power corrupts absolutely. And clearly that is what is coming out. Now, obviously, we'll give Mr. Murdaugh the case, but I'm telling you, this is going to get good. And for those of you who are familiar now, Alex Murdaugh was indicted on 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime. His alleged victim, his 52-year-old wife, Maggie, and their 22-year-old son, Paul, who were shot and killed on June of 2021. Now, there was a hearing this morning, and it kind of descended into chaos in basically less than a minute after the attorneys for Mr. Murdaugh interrupted a prosecutor to accuse him of trying to hijack the proceedings and hide evidence. Mr. Murdaugh's attorney said, "I don't trust the state to honor the rules. They haven't so far at this point. That's what Mr. Harpeltulian said in the Colton County Court, accusing prosecutors of hiding the ball. Now, authorities say the mother and son were both found fatally shot near the hunting dog kennels at the family's 1,700-acre hunting estate there in Hampton County. Now, Murdaugh was the one who made the 911 call. Now, while details into the prosecution's case remain somewhat limited, an indictment alleges Maggie was killed with an assault rifle while attempting to flee the scene. A shotgun fatally struck Paul at a very close range, it's alleged. Now, Mr. Murdaugh's legal team claims that since his arrest, the South Carolina Attorney General's office has engaged in a campaign to leak information about the tight-lipped investigation into Alec Murdaugh, the now 54-year-old former lawyer. Now, last week, Mr. Harpeltulian and his co-counsel, Jim Griffin, filed a motion to compel to force the state to turn over all of the discovery on the Murdaugh investigation, claiming they are missing 100% of the evidence. So during the Monday hearing, Harpeltulian even attempted to call a South Carolina Law Enforcement Division agent, aka SLED, as a witness. That's what they call the South Carolina Law Enforcement, not the agent himself. Anyway, Judge Clifton Newman denied the request, and Harpeltulian then asked for a special master or a third-party observer to manage the flow of discovery in this case. Mr. Harpeltulian added, "This is some sort of game? This is not a game. This is Mr. Murdaugh's life." And then he began arguing that the prosecution's action make it seem like they are still investigating his client rather than preparing to go to trial. Now, the prosecutors completely slammed those accusations as baseless in their motion, requesting an order to unseal search warrants, but also seeking a protective order to seal all other evidence from the public before trial. The district attorney there at the Attorney General's office said, "I don't play fast and loose, Mr. Attorney General Creighton Waters." The prosecutors claimed that secret information in this case was probably worth over $1 million, and that he wanted to protect it in the interest of a fair trial. "Your Honor, I have not leaked a thing," Waters added, before indicating he planned to call a witness during Monday's hearing to support his office's request for a motion to compel a gag order. Ultimately, Judge Newman sided with the state prosecutors and agreed to issue a protective order restricting what discovery information gets released to the public. However, the judge also ordered the state to provide evidence to Mr. Murdaugh's attorney, including search warrants that may finally give some details into the case against the former attorney. Now, this fight is going to get good. All right, we have very competent lawyers on both sides, but withholding evidence, well, that's just petty and wrong. As my old boss used to say when I was a prosecutor briefly in the Marine Corps, we'll give them whatever they want, and we're still going to convict their clients. When a prosecutor says that, you know they have an overwhelming case. When prosecutors who play games and hold things back and hide the ball, guess what? That usually comes back to bite them in the butt. Remember, the defense demanded a speedy trial. So is the prosecution holding evidence back so the defense can't prepare and will have to ask for a waiver of speedy trial? I've seen this happen in my own cases. If the prosecutors aren't ready, they will create delay. And remember, when the prosecutors present their indictment or sign a complaint and information, they are saying we are prepared to go to trial. And rarely, they never are. So although some people don't think this is going to be an interesting case, I think it's just going to get even more interesting. And yes, release the affidavits. Let's see what evidence they have or they don't have against the former attorney whose family basically allegedly ran a criminal enterprise for the last 100 years there in the Low Country. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Next on the docket, sit a little longer. That's right, that OnlyFans model, Courtney Clenny, who was arrested in Hawaii on August 10th regarding the stabbing death of her 27-year-old boyfriend, Christian Omboncelli. Well, Miss Clenny, who also goes by Courtney Taylor on social media, has been dating Omboncelli for a while. The pair shared an apartment in Miami, and Miss Clenny now faces second-degree murder charges. Well, on Friday of last week, Miss Clenny was extradited to Miami and is now being held at the Turner Guilford Knight Correctional Center. And on Saturday morning, she appeared for bond court. Now, the lawyer for Miss Clenny, a guy by the name of Frank Prieto, doesn't believe the charges fit his client's crime. He stated, quote, "I feel it's important that the court be made aware that the warrant that judge signed, that he did find probable cause. However, there's not probable cause for second-degree murder. At the best, it's maybe manslaughter." Now, the lawyer claims that there's been a lot of misinformation has been spread, and officials have only shared damaging text messages with the public. Mr. Prieto added that the detectives also indicated there were no signs of bruising that was consistent with Miss Clenny. He stated, "I was at the homicide unit, and I have photographs of her bruising." Judge Jacqueline Woodard intends to give the case to another judge. She stated, "I don't want to make any sort of ruling and then jeopardize any sort of right for ruling you'd have in front of a judge who may be more familiar with the facts of the case. For all those reasons, I'm going to abstain." That's a classic fancy code word for punt. "At this moment, from interjecting my opinion and allow this case to be reset in front of the judge who is going to handle the case." Now, Ms. Clenny is scheduled for her next court appearance on September 6th, so she will have to sit a little longer. Now, bond should have been set because everyone's entitled to a bond unless it's a first-degree murder case, and this is not. Now, for those who maybe haven't seen this case before, it's alleged that the OnlyFans model threw a knife at Omboncelli from 10 feet away. Autopsy reports from the medical examiner's office dispute those claims, and the documents, the affidavit, show that his wounds were 3 inches deep and resulted from forceful pressure, according to that. But anyway, her bond has been denied. Now, the judge arguing that there is no probable cause, I get that. That's what happens usually at first advisement. And you politely tell the judge, "Did you read this affidavit, you knucklehead, or did you just rubber stamp it?" Now, understand, it takes a very, very low level, right? Probable cause. Probable cause is kind of like here. And then you have proof beyond a reasonable doubt, which is the legal standard at trial. Okay? Big difference. Big difference. But sometimes you can get the judge to find that there is no probable cause, or say, "You know what, maybe I did jump the gun a little bit because I didn't read it that closely because, the officer emailed it to me, or he came into my chambers and he kind of stood over my shoulder and I was a little pressured. And so I went ahead and signed it." It happens, ladies and gentlemen. They're judges. They're human. They're human beings. Some of them get in for the love of the law. Some of it get in because they don't want to do private practice anymore, or they don't want to do what they were doing anymore, and they think maybe this will be a good thing to do. And, their days are done by 2 o'clock if they get through their docket. I know it's hard to believe. It's hard to believe, ladies and gentlemen. But yes, they're human. Judges are not perfect. Hell, that's why we have appellate courts. Tell the lower court judges you're not perfect. And then we got another court above that to say, "Hey, you appellate court judges, you're not perfect either. You don't always get it right. Let us tell you what is right." Anyway, we'll continue to follow that case as well. Next, has this case taken forever or what? That's right. The first trial in the case of 8 members of a single Ohio family shot to death more than 6 years ago is about to begin after several delays related to the, obviously, pandemic and negotiations with other defendants. Now, the defendant, George Wagner, was charged in Pike County back in 2016, alleging the slaying of the Rhoden family near Piketon in southern Ohio. Now, Mr. Wagner faces the death penalty if he's convicted. Jury selection was expected to start today in Waverly County, which is about 65 miles south of Columbus, with opening statements expected to begin next week. Now, police allege the shootings of 7 adults and a teenage boy stem from a dispute over custody of Jake Wagner's child with one of the victims. Wagner's parents and his brothers, Jake Wagner, were also charged. Now, Jake Wagner pled guilty last year in the shooting, admitting to killing 5 of the victims. His plea was part of the deal with prosecutors that spared him from the death sentence. Now, Wagner's mother, Angela Wagner, also pled guilty to helping plan the slayings. John Parker, a lawyer representing George Wagner, has argued that the deal Jake Wagner struck with prosecutors limits his ability to conduct a thorough cross-examination. And Mr. Parker has said that Jake Wagner told prosecutors that his brother didn't shoot anyone. Jake Wagner isn't in a position to testify truthfully because he faces the death penalty if he doesn't strictly obey the terms of his plea deal, Mr. Parker said. Now, Special Prosecutor Andrew Wilson has said that there's nothing unusual about Jake Wagner's plea deal and added that his testimony will be bolstered by other evidence implicating George Wagner. So Jake and George's father, George Billy Wagner III, has pled not guilty. Now, the fatal shooting at the 3 trailers at a camper near Piketon in April of 2016 stunned residents in a stretch of rural Ohio and launched one of the state's most extensive criminal investigations, which led to the Wagners' arrest more than 2 years ago. The Wagners spent months planning the killings, motivated by a dispute over the custody of the daughter Jake Wagner had with Hannah Rhoden, as prosecutors allege. They targeted some of the victims, but some sadly were killed because they happened to simply be there, according to the allegations made by the special prosecutor. Most of the victims were repeatedly shot in the head, and some showed signs of bruising. 3 young children at the scene were unharmed. Now, the victims were 40-year-old Christopher Rhoden Sr., his wife, 37-year-old Dana Rhoden, their 3 children, 20-year-old Clarence Frankie Rhoden, 16-year-old Christopher Jr., and 19-year-old Hannah Clarence Rhoden, fiance to 20-year-old Hannah Gilley, Christopher Rhoden Sr.'s brother, 44-year-old Kenneth Rhoden, and a cousin, 38-year-old Gary Rhoden. The Wagners allegedly used guns with homemade silencers, allowing them to kill the victims as they slept, according to the prosecutors. This is going to be a good, interesting case. I remember when this case happened, I was like, oh, this is going to be good. And then they basically charged one family for the killing of another family. It was like a Hatfield and McCoy. Okay, next on the docket. This kind of goes into the you can't make this stuff up, right? What did the 85-year-old sex offender want to do? Let me tell you, he tried to purchase a girl for $100,000 at a local grocery store, according to police from Port Orange, Florida. Now, Helmuth Kolb, 85, that's right, 85, was already on the sex offender registry for the 2018 charge of false imprisonment of a child under the age of 13, having pled no contest in that case. Now, no contest, just so you're clear, means I'm guilty. It's just a way of saying, I'm not saying I did, I'm not saying I didn't, but I'll take the consequences that come with it. It's a guilty plea, okay? Let's be clear. So on August 25th of this year, after a thorough investigation, the Port Orange Police Department Special Investigation Unit responded to the Sterling Chase Drive-In in Port Orange. Cops said in a statement that the officers arrested Mr. Kolb there, and they said, according to the police, Kolb, back on August 16th, was at a local Winn-Dixie grocery store. While at the store on that date, Helmuth Kolb attempted to purchase a female minor child for $100,000 from her parent. Due to the parent's clear concern that someone was insistent or attempting to purchase their daughter in a grocery store, obviously the police were notified. Unfortunately for him, we were able to confirm through his probation officer that Mr. Kolb is currently on probation for similar issues, and he is not to have contact with a minor child. Now, Laura Benning said she first believed Kolb was only a lonely old man when he talked to about her 8-year-old daughter at the Winn-Dixie. He just came up and he started making comments about how pretty she was and how good her dancing was and how he could never have children and that he wanted children, she said. Well, that allegedly changed after he found them outside the store. He approached me in the parking lot, she said, actually chased me down in the parking lot, according to her, and said, "Hey, I want to make a deal with you. I'd like to buy your daughter for $100,000. Needless to say, Mom was in complete shock. Well, Miss Benning said her daughter no longer wants to go to the grocery store with her. Can you imagine why? So in 2018, Mr. Kolb had a case that ended up being sentenced to 5 years of probation for grabbing another girl at a store, Walmart, kissing her wrist and offering to purchase her for $200,000. As for the new allegations, police are still investigating and want to know if anyone else has had similar encounters with this creepy old man. Mr. Kolb remains without bond in county jail for allegedly violating probation of his 2018 false imprisonment case where he tried to buy a little girl. Just saying. Past performance is indicative of future results, right? The old thing, what does a sex offender look like? Well, apparently he looks like Grandpa. Crazy. All right, next on the docket. They'll never know. They'll never know. That's what a North Carolina man thought when he tried to engage in a drug distribution network. Let me tell you what happened. It didn't turn out so well. So this North Carolina man has been sentenced to a sentence of 40 years in federal prison. His name is Rashad Jamar Everett. And authorities say, and it's been proven beyond a reasonable doubt, that he ran a scheme out of an in-home daycare he operated with his wife at several locations. Now, the ring landed on law enforcement's radar, starting with one of those other locations, according to the police. And the police determined in 2018 that he was dealing large amounts of illegal drugs from an apartment in Fayetteville. Then on July 16th of that year, agents did a traffic stop on a Cadillac driven by a co-defendant, a guy by the name of Alvin Milton Davis, finding some marijuana, cocaine, and a loaded handgun with an extended magazine. This is all according to the feds. Now, the federal official said that the authorities executed a search warrant on the apartment in question, finding more than 36 pounds of marijuana, more than 300 grams of cocaine, and a loaded Scorpion firearm. Now, according to investigators, Mr. Everett leased the apartment with David as an authorized occupant. Now, Davis is currently serving an 11-year prison sentence, and authorities learned that Mr. Everett's primary residence was an address on Ronald Reagan Drive. He and his wife ran an in-home daycare center there, the police confirmed. And then on July 17th of 2018, agents received a search warrant for the residence and said that they seized about $65,000 in cash, 8 firearms, ammunition, and some THC edibles. Nothing illegal about that, I guess, even North Carolina, other than maybe the edibles, right? Now, according to authorities, there was also more than 65 pounds of marijuana in a storage unit that Mr. Everett used. Well, that's probably illegal. Anyway, authorities said that Mr. Everett was responsible for more than 5 kilograms of cocaine and more than 1,700 kilograms of marijuana. Now, evidence introduced at trial also showed that Mr. Everett attempted to engage in a variety of tactics to obstruct prosecutors and investigators. These tactics included giving false testimony under oath, attempting to bribe or threaten others to give false testimony, utilizing gang members to intimidate witnesses, and engage in an extensive social media campaign to falsely accuse the Fayetteville Police Department and the Cumberland County District Attorney's Office of wrongdoing. Now, Everett had told the newspapers back in August 2019 that he was innocent and he had no knowledge of the drugs found at his home, though he acknowledged possession tens of thousands of dollars found at his home. He asserted cops planted the drugs before serving the search warrant and that officers were engaging in a publicity stunt. What else to make a great story but to put things in places, especially behind a daycare? Everett told the news. That makes it a great story. Now, his first trial ended in a hung jury, and apparently they believed that that was a true story, Mr. Everett. Anyway, 40 years, long time. Going to serve 85% in the feds. Long time. Going to be an old man if he gets out. If he gets out. Finally, our dumb criminal of the day. Deputies arrested a man only identified as Mr. Buckley, who they said allegedly tried to choke one of his relatives during a fight over a toaster oven. That's right, a toaster oven. The argument eventually escalated into a full-blown fight, with Mr. Buckley knocking the victim over, punching him, biting him on the neck, and then wrapping his arm around the family member's throat to choke him out, all according to police. A female relative saw the fight and tried to do what anyone would do and tried to get Mr. Buckley to stop by yelling at him and trying to pull him off. Fearing for the victim's life, the woman took a knife and stabbed Mr. Buckley in the back to get him to stop, according to the police. Deputies said the victim was also stabbed in the shoulder with the same knife, but was expected to recover. When speaking to deputies afterwards, the female family member said that she was afraid that Mr. Buckley was going to kill the male family member if she didn't intervene. She also told investigators that Mr. Buckley is a known drug user and has been awake for several days before the incident. Mr. Buckley fled the home before deputies arrived. However, he was arrested after canine deputies tracked him to another home. Now, the Flagler County Sheriff said that Buckley has an extensive criminal history. You don't say. And he was high on meth? Because he's been up for several days? Well, anyway, this guy's been booked at the Green Roofs Inn 6 times since January 2021. The sheriff said 4 of those bookings are for domestic violence-related incidents. He needs to get off drugs and control his anger. I commend the family member for stopping the attack before somebody was killed or seriously injured. I do too, Sheriff. At least it didn't involve food. It only involved a toaster oven. Who knows? Don't burn the toast. Don't burn whatever you put in the toaster oven. What is it with these people and food? I don't get it. Makes people jittery, particularly when we've been on meth for several days, I guess. Don't do drugs, folks. Nothing good comes from it. All right. Thanks for watching. I hope you have a wonderful remainder of your day, and we'll see you next time on Crime Talk.